Spousal disqualification is different than spousal privilege or marital privilege. Marital privilege is where a spouse can decide whether to assert that privilege and not testify against their spouse if they want, other than limited circumstances. Spousal disqualification means that a spouse cannot testify about private conversations between the spouses that occurred during their marriage. That means that can't be waived by either party. It just cannot be testified about. Even if the spouse wants to testify about those marital communications, those private communications, they're not allowed to. It just wouldn't come in as evidence. There are a lot of exceptions, though. For example, if there's a criminal action in which one spouse is charged with a crime against another spouse, then those conversations that were related to the alleged crime, those can be testified about. Or if there's a child abuse allegation or some sort of sexual assault against a child, those types of conversations that are related to that allegation can be testified. If there's a child abuse allegation, if there's a sexual abuse allegation against a child, those conversations that are relevant to that allegation are going to be admissible in court, and there is no disqualification, or rather there's an exception to the disqualification. Sometimes in a criminal case, a spouse can be compelled to testify about personal communications if that is to seek or elicit a bias or prejudice on the part of the testifying spouse. So every case is different. Don't take this as legal advice, but it is an interesting topic, and it affords a lot of confidence in married couples being able to speak freely. And I think that's the reason for the law, or for the exception, is that married couples should be able to confide in one another without risking that the other spouse will be subpoenaed to testify against them at trial and disclose those innermost conversations that are between spouses in the confines of their own privacy.